All right, we're on the record this morning. First case is People versus Kyle Karsten, file number 246756. If I can have counsel put your appearances on, please.
Morning, Your Honor. For the record, my goal on behalf of People.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Karsten.
Thank you. We're on the record this morning for purposes of a sentencing hearing in this file. There are a couple of matters we need to address prior to that. Mr. Trush, you filed a motion for a new trial. I did have a chance to review your motion and supporting brief. I did receive your response as well. Mr. Roll, I had a chance to review that. So Mr. Trush, any oral argument that you would like to make today?
Your Honor, actually, I would like to briefly take some testimony from Detective Voss. I think I have an obligation to support on this record the thrust of the allegation within the motion. At least my reading of the case law is I have an affirmative obligation to do that.
All right, Mr. Roll, any objections?
And I will keep it brief.
Okay, is Trooper Voss available? Let's see here.
Sitting behind me.
All right, okay.
We made sure he's here, Judge.
All right, thank you. Trooper Voss, if you'll come up to the witness stand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. And please state your first and last name for the record.
First name is Jamie, last name is Voss.
Thank you. Mr. Trush, proceed when you're ready.
Thank you. Detective Voss, you were the officer in charge of this investigation.
That's correct.
And I'm going to refer to two different sets of videos. I'm going to refer to one that's the video taken out of a camera video, and the other that's from, I'm going to call it from the cloud. If I refer to it that way, do you know what videos I'm referring to?
Yes, I do.
So the video that was taken on a phone, it's a video of the video. Were you there when that was done?
Yes.
And was that done on the night that the incident occurred?
No.
Was that the next day?
Yes.
At that same time, was there a second set of videos that you collected?
On that same day, yes. Not at that same time.
How was that second set of videos collected?
By utilizing what you refer to as the cloud or the app, the Blue Ram app. Detective Sergeant Geyer logged in consensually to Karen Karsten's account and recorded videos from that Blue Ram account. Well, on a desktop at the gate post.
And when you say recorded, you mean he collected the videos from it?
And put them on a CD, DVD.
So is it fair to say that the recording of a recording and the videos from the cloud were in your possession for virtually the same amount of time?
Yes.
In regard to the second set of videos, were those edited in any way by the computer crime team?
No.
To the best of your knowledge, did they ever go to the computer crimes unit at all?
No, but they did not.
To the best of your knowledge, those videos were independent of the recording of a recording, correct?
Independent items of property and recorded at separate times, different locations, yes.
Did you have an opportunity to view both sets of videos in their entirety?
Yes.
While there is some overlap, did they cover the exact same time frames?
No, they didn't cover the same time frames because some of the recordings that were recovered from the app were not things that were they occurred after, like the police arriving at the scene, things that would have been on the body cam stuff.
And then likewise, the recording of a recording is a longer clip in its entirety.
Yes, the recording of the recording was stopped at our discretion when we were recording it shortly after Kyle had exited the residence, after he passed the view of the camera, and Karen was walking around. I believe she was looking for her phone at that time to call 911.
Now, The recordings that you recovered from the cloud, were those a clearer picture?
Yes, they were a clear picture. The ones that were recorded from Karen's phone were a screen recording holding another cell phone, Detective Sergeant Geyer's cell phone, recording that. So yeah, it would have been clear.
Okay, so I want to jump ahead. What did you do with those videos once you got them?
They were made items of property, burned to DVDs and placed in the property room, and then uploaded to Carpel.
When you say uploaded to Carpel, is that how you provide videos to the prosecutor's office?
That's correct.
Did there come a time when you realized that the prosecutor was unaware of those videos?
Approximately 3 weeks before the trial, I was prepping for the trial, reviewing everything that was available on Carpel that had been uploaded, and I could not find the second set of videos on there. So DVDs were made. That item was removed from the property room. DVDs were made, one for the defense, one for the prosecutor, and sent to the prosecutor's office. I think that was on the 7th. I don't remember what day the trial started.
And then prior to the trial, we had a conversation when I had received the videos.
Yeah, she called me and asked me about the videos that were recorded from the app.
And the background that you laid out today, it's substantially similar to the conversation we had.
Yes.
So the second set of videos, the ones from the cloud, they're not enhanced or edited in any way, shape, or form.
No.
I don't have any additional questions.
Okay, Mr. Rolla.
As to that last question, the videos downloaded from the cloud, you said they're not enhanced or edited in any way. Comparing the, what we call the cloud video, the 1.2 minute video of the second shooting, you know the one I'm talking about. That was the one that was downloaded by Detective Sergeant Carr, correct?
Correct.
The evidence contained in that, is that also contained in the 8.5 original video that was taken from Karen Carson's phone?
Yes, sir. Yes, it is.
Now, so is it fair to say that since it's the same information, it's just less of it, that 8.5 video was edited to only show effectively a smaller amount?
That's correct. The way that it records in clips, the Blu-ray app, like you can't get an all-inclusive playing of the incident. It's just segmenting clips. And that was the only clip that we were able to recover because the other ones were deleting as Detective Sergeant Geyer was recovering them, which is kind of standard in those types of platforms. They're on a loop and they will delete after a certain amount of time.
As the Detective Sergeant Geyer testified to at trial.
Correct.
Now, if you know, and if you don't know, fine, but if you know, the original source material that the 8.5 approximate minute video that you copied from Karen Carson's phone, where did that video come from?
That video came from the Blu-ram app that was on Karen Carson's phone that she allowed us to log into and record from.
From the original source material?
The original source material.
The same or different original source material that the 1.2 video clip came from?
The same, just a different device utilizing to view it.
So would Karen Carson's video be kind of like a middleman for you copying? In other words, you could have gotten it from the cloud, but you could have gotten it from her copy. It doesn't change the original source material.
Correct. We screen recorded it because we were concerned it may not be available. So we just tried to recover what we could immediately, knowing that it was evidence of the crime.
So would it have been accurate to say that the 1.5 video came from the same video source as the original 8.5 minute video?
Yes.
but a shorter clipped version,
Shorter.
an edited version.
Segmented, yeah, whatever, however you want to call it, segmented.
Now, you indicated that my apologies, the state police had that second cloud recorded video for some time.
Correct.
And you said there came a point in time where you noticed it had not been provided to the prosecution.
I noticed it when I was reviewing things that were, every item, as you know, on Carpel is listed, and I can click on them, I can view them, and it wasn't on there. So I went up and confirmed with Angela. I had her physically pull up every single thing that she had saved, and I went through everything. And I said, it's not on.
And for the record, Angela is the office manager for the Otsego County Prosecutor's Office.
Yes.
So once you found that our office was not provided with that information, you did what?
I had 2 copies made, one for the prosecutor's office, one for the defense. And instead of uploading them to Carpel, I had them burn 2 DVDs and provided them to the prosecutor's office.
And that was on the 23rd of April.
It was, yeah, it was, if you should, I don't know the exact date, I would have to look back and see.
Fair enough, but in any case, at or about the time they were then immediately provided to the defense.
Yes.
And that was before or after the start of Mr. Carson's trial?
Before.
5 days before.
You say so. Yeah,
Well,
it's
his trial started on the
yeah.
28th, they were provided on
Okay.
the 23rd. How many days is that? So is there any question in your mind that second cloud video or the 1.2 minute video clip, however you want to say it, had been provided to the defense prior to trial?
There's no question in my mind that it had, no.
And in fact, they've acknowledged as much.
Yes, I mean, I actually spoke to Mr. Trush the week before the trial. And we had the discussion that you just asked.
Regarding that 1.2 minute video.
Regarding.
And could you have had that discussion about it had they not received it yet?
No.
Thank you. I have nothing further.
Mr. Trush, you follow up?
Very, very briefly. The prosecutor asked you if the second set of clips from the cloud, if they're trimmed down or edited. I just want to make sure we make a clear record. You made no edits, changes, or anything from what you pulled off the cloud.
No, Detective Sergeant Geyer did not edit that.
Okay, so that second set of videos, it's not altered in any way from what was pulled from the cloud.
Correct, it's not.
And it's not any way derived or pulled from that first video. It's a separate source.
It's a separate source. Well, it's the same, I guess it would be the same source, just a separate location and device utilized. Like he utilized his state laptop to download it. Where at the scene, or I'm sorry, at Karen's house, we utilized Detective Sergeant Geyer screen recording for phone.
And you would agree that in the second video, it's much clearer, and particularly up in that sort of upper left-hand corner where things are happening is a lot clearer.
It's clearer, obviously, because of the mode of downloading. Yeah.
I don't have any additional questions. Thank you.
All right. Now we're making a record here that's going to be scrutinized by somebody later on, and then so I want to be clear for that, and I also want to be clear my own information, make it ruling here eventually. The 1.2 minute clip that was downloaded from the app, which I'm kind of calling clip number 2. The information on that was also on the 8.5 minute recording that you made using your phone.
That's correct.
So there's no new information.
There's nothing new.
Okay. Yeah. But the difference is, as Mr. Trush alluded to, it may be clearer because it's coming directly from the app as opposed to being recorded as a screenshot from somebody else's phone.
That's correct.
Okay. And that 1.2 minute clip, you've watched that, correct?
Yes.
Okay. How much of the interaction, or I guess what I would call shooting, is on that 1.2-minute clip versus just stuff that happens after when Ms. Carson's looking.
So it basically starts right about when that second shot occurs, the shot that was in the hallway threshold of the building.
Thank you. Any follow-up to my questions, Mr. Church?
No.
Thank you.
Thank you, Chief Regency. All right, Mr. Church.
Yes, Your Honor. I just want to highlight essentially the three separate bases that I think the court would have to grant the motion that I have filed. So first is obviously under Court Rule 6.201 that governs discovery. This would be mandatory discovery. It's required to be disclosed and provided 28 days before trial. That didn't happen here. The witness and exhibit list couldn't have contemplated this. It couldn't have contemplated it because the prosecutor, by the testimony, didn't know it existed at that time. So he couldn't have contemplated that in the witness and exhibit list to be filed. Additionally, under Brady, we have some case law that is important. And I think it's important not just for its implications to Brady, but for its implications, because, I mean, Brady is an interpretation of that discovery rule. But it's important for the analysis under the discovery rule, under Brady, not so much under the court rule I cited. But you have U.S. versus Giglio, which establishes that even if it's a good faith mistake, which I believe is what's occurring here. I mean, from what we heard from the detective, I don't think they intentionally withheld this with the intention of sandbagging. I don't think that's what happened. I think they tried to upload it for whatever reason it didn't. But under Giglio, good faith is irrelevant. It doesn't matter if they intended to withhold it or not. The question is whether it was withheld and whether it's material. Secondly, even if the court sort of got around that under Kyles versus Whitley, and again, both of these are cited in my brief, the police knowledge is imputed to the prosecutor, meaning even if the prosecutor didn't have it and didn't know about it, that doesn't avoid the issue because we know the police knew about it. They had it at virtually the same time that they had the other video. And I think there's a couple things that become really relevant for the court to consider here as well. I mean, one, I would agree insofar as, you know, it's a clip that shows a portion of what occurs in the larger clip. But there are some really important distinctions here. In the second set of clips, there's at least two distinct things that you can visibly see that you can't see in the recording of a recording. One of which is you can clearly see where Miss Karsten, where Karen Karsten is. And that becomes incredibly relevant because there's a great deal of testimony and trial impeachment of where she's standing when it happens. There's questions based on what her statements to the police are, what her testimony in trial was, whether she's in the hallway, in her bedroom, or in Kyle's bedroom. So, I mean, this is an incredibly important fact to know. Additionally, the other thing that you can see in that second set of cloud videos that you can't see in the initial video is where Lee is. So that is to say, you can clearly tell in the second video when Lee falls into the frame. Meaning, when Karen or Kyle both indicated that at the time of the second shot, he was sitting up, that's supported in that video, clearly, because you can't see him until he falls into the frame. These are incredibly important facts that are available in that video, but are not available in the first video. I'm also going to indicate to the court, we know the videos were important to the jury in their determination because they asked for an HDMI cable to hook the computer up to the TV. So we know that it was something that they were strongly considering. And lastly, I'm going to talk a little bit about the court rule 2.612. This has to do with the misrepresentation from the prosecutor. And again, I don't think it matters if it's intentional or unintentional. But the prosecutor at the motion hearing, and again, we have a situation where I'm provided this discovery the Wednesday before the trial starts. I believe it's the 23rd. I think that's accurate. The 25th, the Friday, we have a motion hearing in regards to this. At the motion hearing, I outlined to the court a very consistent with what Detective Voss here indicated in terms of the background of what happened. The prosecutor indicated that it was enhanced video that had been edited by the CCU. He went as far as to tell you at that hearing that he was going to have a tech from the CCU testify to how they made the edits to it. He referred to it as enhanced. He referred to it as edited. None of those things are accurate. And I think it's important to recognize how it influenced the court's ruling. And the reason I say that, because the court made an analogy when it made its ruling that it is not apt, but it's important because it gives light as to what the court was thinking when they made that ruling. So the court's analogy was, this is like having a photograph and then zooming in on the photograph. That's not an apt analogy. And one of the prosecutor's arguments and the issue that came up is, well, defense could have gone and had their own expert, right, enhance this footage. Those things are false. We could not have gone and had our own expert produce this second set of videos. That's not possible. But also, the apt analogy isn't, it's a photograph that you zoom in on. The apt analogy is you photographed a scene with a standard lens and photographed it a second time with a wide angle lens and didn't provide the second set of photos. That's the apt analogy, because there's more visible in the second set of videos. In that analogy, I think the ruling from the court would be distinctly different. We know that the officers had this for 6 months before the trial. I don't know how many times or how many officers had an opportunity to go through that footage, how many hours they could have spent poring over it. We had it for 5 days. I'll leave it at that, Your Honor. I think that there is clearly a basis on the discovery violation, the Brady violation, or the court rule violation, particularly, again, whether intentional or unintentional, the misrepresentations to the court that directly affected the court's ruling on the admissibility. Thank you.
All right, so question. If we look at this as, well, let me start by asking you this. If the prosecutor had provided you this clip number 2, the 1.2 minute clip, I'm going to call it clip number 2, 28 days before trial, would any of these arguments hold water?
If he had provided it 28 days before trial, I think the answer would be no.
Okay, so what we're dealing with is a delay of 23 days. And what prejudice does that delay give to the defense that would require the court to reverse the conviction in this case in order of new trial?
I would agree. Well, insofar as my position is the last argument in regards to the misrepresentation, I mean, that's somewhat independent of the timing.
Right.
I mean, if it had happened 28, or hypothetically 27 days before trial and we had the same motion arguments, I still think the same problem would occur if the arguments played out in the same way.
Right.
But I would tend to agree with the court if he had provided it 28 days before the trial. I think he's complied with Brady and he's complied with the discovery rules.
What would you have done with those extra 23 days and looking at that video that you couldn't do in the 5 days that you had?
Well, I mean, Your Honor, it's a factor of hours. I mean, again, we're talking about 3 additional weeks of time that I could have spent looking at it, preparing for it. It could have changed the arguments that we made. It could have changed the witnesses that we choose to bring, because knowing those concrete facts, knowing that we have concrete evidence that Lee is sitting up at the time the second shot happens, could change the way the defense is presented. Knowing conclusively where Karen Karsten is could change the way the defense is presented, because that becomes a big issue in terms of what she can see, what she can't, and again, the credibility of her testimony.
All right, but what you're seeing on that 1.2 minutes isn't something brand new, right? It's not something that you've never seen before. It's a clearer view of what you have already viewed.
Yes and no. And I say no because in the video of a video, the first clip, you cannot see that Karen, in the second clip, you can see Karen is in that hallway. I mean, you can see her standing right there. You can see her react to the things that are happening. In the first video, you can see motion in that corner, and that is it. You cannot tell who it is. You can't tell what they're doing. In the second clip, you can see Karen. You can see her reacting to the shot. You can see her. It's hard to describe it, but it almost looks like she's like running in place when it happens. She's shocked and her legs are kind of pumping up and down and her hands are up like this. You can clearly see these details in the second video. You can clearly see where Lee is in the second video. So, I mean, I agree with the court that, yes, it encompasses what's in there, but I mean, the differences in what you can see are dramatic.
Yeah, all right. I think I understand your argument. Thank you.
Thank you.
Mr. Rowland.
Thank you, Honor. Let's deal with that last part first. Defense is alleging to this court that you can't see Karen Karsten in the first video. I just respectfully disagree. What you can see is you see the shadow of someone moving in that corner. Maybe that's what the defense was describing about you can see motion. However, from watching the video in its entirety, you can determine there are only 3 people in the house at that time. Karen Karsten, Kyle Karsten, and the decedent. And once you see where Karen comes from, you know that that motion's her shadow. That's what you see. That's what I was able to tell from watching the video. Then we get to the prosecution misrepresented. The defense is accurate to the extent that the video wasn't edited by the CCU. We admit that. However, up until we heard Detective Sergeant Geyer's testimony at trial, prosecution was in the impression that that's exactly where it came from, because as the court's well aware, that's where the videos come from. We had no information indicating it didn't come from there. I thought we were going to have somebody from the CCU, which is why I made the comments that I did on the 25th of April, albeit turns out that was inaccurate. But what was accurate, and here's the pertinent part, the data information contained in the 8.5-minute video and the data information contained in the 1.2-second clip, same data. It's a situation where it was, as Detective Geyer testified to at trial, as again Detective Voss testified to today, it's from the same source material. And for the defense now to say that they are somehow surprised, they can't, because they had the same information. More importantly, they make the claim that, well, we couldn't have done anything to try and find that source material. Also respectfully disagree, because of course the defense had the first video. They had clearly access to Miss Karen Karsten because, as the court will recall her testimony, she testified in a way, and I understand she's between a rock and a hard place. She has her husband died. She has her son facing murder charges for his death. They had the same access to Miss Karsten in getting the source material as the state police did. They could have done that. They could have done that apparently months prior to the trial. But I respectfully submit, actually none of those facts change the circumstances before the court for the following reasons. If this were a case where the information of the 1.2-minute video, cloud video, second video, however the court wants to describe it, had not been provided to the defense, had actually been suppressed, then their argument would have legal and factual merit, which is why specifically I cited in my response the case of People versus Chanel, 495 Mich 142 at page 150, a 2014 decision by our Supreme Court, which cited U.S. v. Bagley by our U.S. Supreme Court, 473, 677, a 1985 case. Because in order for there to be a Brady violation, as has been alleged by the defense, you have to have 2 things. First, you have to have actual suppression prior to trial, where they don't get it. The facts are clear in this case. At a minimum, the defense had the information, the complained of information, on the 23rd of April, 5 days prior to trial. So at most, this is a late discovery not a suppression of evidence. It's a situation where, and that's why I attached also the case of People versus Willis, citing both Chenault, Fields, Bagley, and Bombro, making that distinction. Now, where there might be a technical violation under the court rule, it wasn't provided within 28 days, because of course it was in the possession of the police, and what's in the possession of the police is imputed to be in the possession of the prosecution. Not making that argument that it's not. However, in this particular case, it's a situation where they don't just have to show that it wasn't provided. What they have to show is they have to show that it was material, and first that it would there be a reasonable probability that it would have changed the outcome. Citing specifically and defining materiality, the Chenault case stated the defendant must also show that there's a reasonable probability that the non-disclosed, and the case actually was disclosed before trial evidence, the result of the proceeding would have been different. I submit to you, in light of the overwhelming other evidence, that's not the case, especially since the evidence in the 1.2-minute video is contained in the 8.5-minute video, albeit not as clear. Second, in defining the term reasonable probability, the Chenault court further stated that reasonable probability is a probability sufficient to undermine the confidence in the outcome. This standard does not require demonstration by a preponderance that disclosure of the suppressed evidence would have resulted ultimately in the defense acquittal. The question is whether, in absence of the suppressed evidence, the defendant received a fair trial, which is understood to mean the trial resulted in a verdict worthy of confidence. In this particular case, I think, Your Honor, in light of the overwhelming evidence, and I don't know in 39 years I've ever had a circumstance where in a homicide case, not only was the homicide caught on tape, but then the defendant, very shortly after the homicide, not only confessed, but repeatedly indicated to the investigating officers, in this case, Detective Sergeant and Detective Geyer, that he did the crime, that he did so intentionally, and that he wanted his father dead because he didn't want his father, again, reporting him to the police. The evidence in this case.
I object. That miscategorizes what the evidence was.
I'm not sure that part of it is terribly relevant to this motion.
In any case, under the cases that I cited, this is not a Brady violation. This does not arise to a situation that it would warrant the dismissal or the granting of a new trial. The defense has not met their burden. They haven't established materiality, and they haven't shown that the trustworthiness of the jury's verdict has not been met. For all of those reasons, Your Honor, we ask this court to deny the motion. Thank you.
Right. Mr. Trush, it's your motion. I'll give you the last word.
Thank you, Your Honor. Just one piece. I think we've belabored the point and made a good record here. The prosecutor suggested we had the same access to this information that the police did, and that's blatantly not true. We heard from Detective Geyer during the trial, and we heard from Detective Voss here today. They were recovering the evidence the day after the incident occurred, before an attorney was ever appointed for Mr. Karsten, before I even knew this case existed. And they testified at that time, as they recovered those videos, they were deleting as they were recovering. So to suggest that we had the same access to this that they did is simply not true. We didn't. By the time I was appointed on this, the videos from the cloud were gone. There was no way for us to recover them. The only copies that existed in the world were in possession of the police. Thank you.
All right, I'm going to take a short recess. I wasn't anticipating we're going to have testimony from Trooper Voss. Parties here, I think, raised some additional issues. So I'm going to take a few minutes. I'll be back on the record with my rulings. Great, back on the record. Thank you everyone for your patience. I do want to say, first of all, there should be no recording, no photographing, no broadcasting live of anything that's going on in this courtroom by anyone unless you're authorized by the court to do that. It's a standing court rule. So there shouldn't be anybody taking photographs, taking videos, broadcasting what's happening here in the courtroom. Again, unless the court has given you prior permission to do so. If I find out that any of that's going on, then you'll be called to answer for contempt in front of the court later. So I don't want to see any of that. There's a transcript that anybody can pay for to obtain. The court is broadcasting this to YouTube. It'll be available for public consumption later. So there are plenty of opportunities for you to view what's happened here in the court for other people to view. That being said, so the court has had an opportunity to review the arguments of the parties, the testimony of the trooper here today, as well as the law cited by the parties. In addressing the defendant's motion for a new trial in this case, on the basis of a discovery violation, a Brady violation, which I think, as Mr. Trush argued, kind of go hand in hand, as well as on the basis of misrepresentation of what the video was at the prior motion hearing before the court. I find the following. First of all, there's no question that the video was disclosed late. I think all parties have acknowledged that. While knowledge of that video is imputed to the prosecutor, the court does note that the prosecutor did disclose that video as soon as he knew about it. And to the extent that it's relevant, the court finds there isn't any willful violation by the people of the timing of that disclosure. I also agree with the prosecutor's argument that this really isn't a suppression, but again, a late disclosure. But even if it is a suppression, or even if you could consider the late disclosure as a suppression, I think under the analysis that the court's required to take, it still does not justify a new trial. The court first would have to find that the suppression or the late disclosure of the evidence was material. In other words, that there's a reasonable probability that had it been disclosed earlier, that the result would have been different, or that the late disclosure itself undermines confidence in the ultimate outcome. Despite having less time, and as we indicated earlier on the record, about 23 days less time, the defendant did nonetheless have 5 days to review that evidence and to adjust arguments based on that evidence. I think it's important to note first that this isn't new evidence in the sense that it showed additional people involved in the incident, that it showed that there were more or less shots fired, that there was a different timing of those shots. In other words, they occurred at different intervals. It doesn't provide a different angle or a different point of view of the incident. And it doesn't provide any kind of different sequence of events in terms of the order that things happened in this case. What it provided is essentially, again, a better view of what the defense had already seen. I accept Mr. Trush's position that, there were things that were visible on that video, and to that extent, I guess it could be characterized as new. In other words, it was easier to identify the exact locations and movements of Ms. Karsten and Mr. Karsten Lee. But again, it wasn't new evidence in the sense that it showed something materially different than what defense already knew had occurred. And that video doesn't materially change any of the basic facts of this case, again, in terms of the sequence of events, point of view, the number of shots, and the timing of those shots. The defendant, again, although it was shortened to 5 days, had an adequate opportunity, in my view, and an exercise of my discretion in light of the entire case, had adequate time to adjust cross-exams, direct exams, arguments regarding the positioning of the individuals to adequately address what little new info could be discerned from that additional video. And again, it's not like 5 days before the trial, the defense was provided with some kind of bombshell new evidence. It's provided some additional information, but again, in my view, 5 days would have been enough time, given the nature of that new information, for the defense to make the adjustment necessary. The other thing that I would note, although I find it to be less relevant than what I've already indicated in terms of materiality, is the jury's ultimate verdict in this case. They found the defendant guilty of first-degree premeditated murder, and the jury instruction on that is heavily weighted towards discussing timing of events. It indicates that the jury has to find that the defendant considered the pros and cons of the killing, thought about, chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It's for you to decide if enough time passed under the circumstances of the case. Killing cannot be the result of a sudden impulse without thought or reflection. And as the court must do, it presumes that the jury will follow these jury instructions, which means that there's a reasonable, or I think the court can make a reasonable inference that it was the timing of the shots, not the actual locations of the individuals. Their exact movements would have been shown during that additional clip. Rather, again, the timing that was much more crucial to the jury's verdict in this case. I think we make a reasonable inference of that given the nature of the instructions in the jury's verdict. And in addition, the jury got to see the videos. The defendant had a chance to argue the enhanced version to the jury and what the defense believed that it showed. The jury clearly rejected that in arriving at its verdict. So all of those things together lead the court to conclude that the late disclosure of that video, it could be termed as suppression, did not affect outcome, it did not materially affect the defendant's ability to make the arguments that they wanted to make at trial to the jury. And the court cannot find that even if it had been disclosed earlier, that there would have been a different outcome given all of the evidence in this case. Aside from the materiality, the court would also have to find that the evidence was favorable. And I simply, again, don't find that what was on that additional clip was exculpatory in nature. It doesn't tend to show a lack of premeditation. It doesn't tend to show that the defendant was acting in self-defense. In my view, that additional information, clear positioning of individuals doesn't really help or hurt either side. Again, so I don't even find, even if it was material, that it's necessarily exculpatory such that Brady violation occurred. So ultimately what the court finds is that this was an inadvertent discovery violation that was disclosed prior to trial, that was addressed by the parties before the court on the record. The court made a ruling in which both sides had adequate opportunity prior to the actual trial date to prepare to argue that new evidence to the extent it was new, given the nature of that evidence, a little bit that it did add to either side of the case and its material case. The court finds that that is not a basis either because of the discovery violation or Brady violation order in the trial. In terms of the argument regarding the misrepresentation, I will say that I was under a different impression of what that new clip was at the time that we had that pre-trial motion hearing. However, much more important to my determination of the admissibility of that clip, given its late disclosure, was not where it came from or the technicalities of how it was produced, but rather the content of that clip, what was on it, and what was on it that was different from what the defense had prior. And I employed the same kind of analysis. And in my view, whether that was a clip that had been taken out of the original 8.5-minute video, or whether it came from a different source independent of that 8.5-minute video and reported in a different way, doesn't change content and substance. It was on that 1.2 minutes. And therefore, the court's ruling, even if it had been clear on the date of that pretrial motion, the court's ruling would not have been any different, given, again, the nature of that evidence as I've outlined already. So for all those reasons, the court will deny the motion for the trial. And Mr. Roll, I'll ask him to declare an order. All that being said, we have one other issue to address prior to the sentencing, and that is Mr. Trush filed an objection to Lee Carson's nephew's victim impact statement. Mr. Trush, is there anything you wanted to address for the record on that issue?
So just two things briefly. I was provided today in court another victim statement. I believe it's from Lee's other nephew. At least that's how. Yeah, Lee's other nephew.
Niece, though, not.
Oh, actually, it says Brandon. It says Brandon and Nicole. In any event, I would make the same objection to that. I think Crime Victims' Rights Act is fairly clear in defining who is permitted to make an impact statement, specifically in regards to a situation in which someone is deceased or otherwise incapacitated and unable to do so. It lists a series of people who are empowered to make those statements. Those include the spouse of the victim, the child of the victim, if the child is 18 years or older, a parent of the victim, a guardian or custodian of a child victim, a sibling of the victim, which neither Justin nor Brandon would qualify as that. I do think William would qualify in that regard. A grandparent or a guardian or custodian of the victim. So I don't think the nieces or nephews are empowered to make a written or oral statement to the court.
I think on that regard, I agree the court will list a number of individuals that the court effectively is required to allow to make statements. And also the court also is not, however, mutually exclusive. In other words, the court can, in its discretion, allow other individuals to provide information. Should the court not allow those people to provide a statement, that's obviously within the court's discretion. But even as to those people, the majority of them, the court heard their testimony, and I'd be simply asking the court to take that into consideration for the time of sentencing. Thank you, Judge.
All right, so I did review the Crime Victims' Rights Act, although I'm already familiar, this does arise occasionally as part of sentencing. In my view, in my reading of the statute, is it uses the terms such as may. It doesn't say only these individuals shall be able to give a statement. It doesn't say crime victim statements shall be limited to these individuals. It indicates that such individuals may give a statement as a victim. In my view, that gives the court some discretion in determining which statements it will allow and which ones it won't. It's been my practice generally to exercise that discretion liberally, in other words, to allow people on both sides really of sentencing, both on behalf of victims as well as on behalf of defendants, to submit written letters to the court prior to sentencing. I frequently read all of those letters. I have in this case. I think submitting written statements to the court prior to sentencing is also a different matter than addressing the court at sentencing, which I think, again, while discretionary, the court is much more inclined to limit people who are allowed to address the court on the record at sentencing to those listed under the Crime Victims' Rights Act. So I will and have read all the written victim impact statements that I have received, but I will limit the verbal statements here before the court today to those individuals listed under the statute, to the extent that that makes any difference. I don't know if addressed in the court today. Go on.
And I believe they want the written statements just to be part and parcel with PSI, Judge, as to those persons not specifically authorized by the Crime Victims' Rights Act.
Okay. All right. With that having been addressed, Mr. Sure, we're ready to move towards the sentencing portion of this hearing.
Yeah, sure.
Yes, sir.
Mr. Karsten, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yeah.
All right. Mr. Trush, are there any additions, deletions, or corrections that need to be made to the body of that report?
No, Your Honor.
Given the nature of the conviction, there are no scoring or guidelines in this case. Mr. Rolla, do people have any additions, deletions, or corrections?
No, Your
Aside from the written victim impact statements, again, which the court has read prior to the hearing today, do you have any victims that wish to address the court?
Two things, Judge, one of which, and I provided a copy of this to Mr. Trush's wife. I thought it said it was niece he was referring to, because our office did get one from a niece too as well. And that's one of the written ones that's being provided in advance to the court.
Okay.
I understand the court's not going to allow her to speak at sentencing, but again, I would ask that it be attached to the PSI before to make any other arguments.
Okay, just give me a moment here to review this.
And I apologize for it being light, Judge. I think it was written in pencil, and that's the darkest we can get for the court.
Mr. Roll, I've had a chance to review that. Do you have any objections that wish to address the court?
I do, Judge. William Carson wants to address the court. Pursuant to the court's ruling.
Sir, can you tell me your name, please?
William Karsten.
And can you tell me your relationship to the victim in this case?
I'm his brother.
What is it that you would like to say today? You can go ahead and whatever it is you would like to say. I'm sorry, I didn't realize that you.
Okay. Kyle, you got what you wanted to do. That is to get back to those people who you thought hurt you, but you only hurt the ones that cared about you. Your father who loved you as a son, that took you hunting and fishing. Remember that picture of that fight you caught and all the other times your dad took you and your friends and uncles out to the rabbit camp in Hillman that your grandpa Karsten was a member of. Elena, your sister, that welcomed you as a brother. And then you took the smile from her that she would have enjoyed feeling when she presented her son Desmond to her father for seeing his first grandson. Joe, Elena's husband, I know enjoyed being with your father and coming out to camp with him. Kyle, do you remember when your grandma and grandpa Karsten would take you into their home and hold you in their arms and would rock you and talk with you and show you that they loved you as a special grandson? Then when you did not think of my parents, that they had already lost your baby boys, Gerald and Ron, at birth, and then lost their daughter, Janet, 6 years old, to cancer. But Janet told them before going to heaven that she would not be afraid to be an angel. Now they see their son Lee in heaven with them, wondering why their own grandson could have done this to his dad. Now look at my children, Justin, Brandon, and Heather. They love their Uncle Lee. they always welcomed him as their uncle. And when they had their own families, their children always enjoyed him and the times he would spend with them. And now for me, your Uncle Bill, when I was growing up, I always had a void in my heart after losing my sister Janet. I was 5 at the time. She was always there for me, and she still is with me today. But when your father, Lee, came into my life, that started to fill that void in my heart. I would push him around in his stroller, take him for bike rides on his grandma's bike. And my job as older brother was to watch out for him and help him grow, which I did. Even there were times that we disagreed, but we always remembered that we are brothers, and brothers help each other. This past year was a trying times for both of us. Father would call me and want to talk. So I'd either pick him up or he would drive over to Rogers City to have a brotherly discussion. I enjoyed the time spent with him talking. I told him not to hold back on anything that was bothering him. I had learned that it is the best to get it out on the table where somebody could pick up on it and perhaps give some guidance to help them through it. I asked him when he came to me in August, after we had talked, if I was helping him, and he told me yes. That I was the only one that could understand what he was going through. I assured him that I would get him help to work through this, and if he would agree to it. And he said yes. Father called me up about a year ago and asked what I did to get through tough times, and I told him to pray to God. I knew your father had faith in God, that the Lord would answer his prayers, but it may not happen right away, but it will. He told me to keep praying for him and his family, which I did. But I also told him that the good Lord was already helping him by the upcoming of the birth of his first grandson, and to look forward to that very special day. Kyle took that all away from your father, your sister, Elena, and her husband, Joe, and especially that beautiful first grandson, Desmond Joseph. Desmond will miss that time with Grandpa, but your father, Lee, will be with him always. But for me, I've become a stronger person. I can't judge you, Kyle. I know you hate me, but only the good Lord in heaven can judge. And you will help this court to make the right decision. Also, I would like you to know that I did say a prayer for you. That is because your grandpa and grandma Karsten would have asked me to do that.
Thank you, sir. Ms. Roller, did you have any other questions?
Judge, I believe under the Mertz Act, Ms. Karen Carson has the right to stay to by the children. She's the one to do something.
That's maybe you want to have her, your Crime Victims' Rights advocate wants to have a discussion with her. That's not my decision. I think that's the prosecution's office role to determine that.
Your Honor, I just spoke to Karen as well as Elena, and neither one of them desired to make a statement.
Very good. Just want the record to reflect that they were given an opportunity.
Sure.
Thanks.
Anything on behalf of the people for allocation?
Yes, Judge. Well, the people submit, that is our state legislature, has established effectively mandatory sentencing without the possibility of parole for the offense of first degree premeditated murder. As occurred in this case, is that, and as reflected in the defendant's PSI, the Michigan sentencing guidelines clearly do not apply. The people believe that under the facts in this particular matter, which involved the defendant shooting his father twice, approximately 17 seconds apart, with the fatal second shot only being fired at a much closer range after the victim, Lee Karsten, attempted to sit up while asking his wife to call 911, and only after the defendant realized his father was still alive after being shot from behind. It is worth noting, as did our Michigan Court of Appeals in the Hazel Cooper case, when they were dealing with a case where the defendant shot the victim twice from behind and was later allowed to plead to a lesser offense of second-degree murder, down from first-degree premeditated murder, that at the time the second shot was fired, the victim, after having been already shot once in the back and laying face down, was at that time a vulnerable adult. And I understand, Judge, this is first-degree murder and the sentencing guidelines don't apply. The point I'm trying to make to the court is, after that first shot, this was done, again, effectively, to a vulnerable adult. The defendant is trying to paint himself as a victim. In this particular case, the jury, by their guilty verdict in less than 4 hours, clearly rejected that particular statement. This was a homicide, knowing and intentionally committed by the defendant, and done with the defendant clearly and as he unemotionally disclosed to Detective Sergeants Boss and Geyer, done in order to prevent Lee Karsten from continuing to again contact the police. This is the exact type of crime that our state legislature has established the penalty of life without parole. And I have no further comments to the court. Thank you.
Mr. Church, if you and your client would come to the podium, please. Mr. Church, anything that you would like to say on behalf of Mr. Karsten?
Thank you, Your Honor. I will keep this brief. The prosecutors identified there's really no discretion of the court here. It's fixed what the court must do in this situation. I would indicate there's nothing I can say here today to the court that would change any of that. My client maintains his innocence and intends to appeal, and I would leave it at that.
Thank you, Mr. Karsten. This is your opportunity to make a statement if you would like to make a statement today.
No, sir.
Okay. All right. I read through the pre-sentence report. I'm familiar with all the information contained within that report. Most of the new information that I read, Mr. Karsten, was related to your background and your circumstances. I'm fully aware of all of the facts relating to the incident in this case, and a lot of background information about you and your family based on the evidence that was introduced at trial. I take all of that information into account, along with what victims all had to say. Clearly, Mr. Lee Karsten had a very loving family, cared about him very deeply, and are going to miss him very deeply. And that came through in all of those statements. And certainly the way that these crimes affect, particularly homicides, affect those who now have to go on without their loved one, has an impact on court and sentencing. So I appreciate all of those statements that were made. I take all of that into account along with what each of the attorneys have had to say. I think what the lawyers have indicated here is, of course, accurate. The court doesn't really have any discretion in terms of deciding what an appropriate sentence is for you. Given the verdict in this case, the legislature has decided that as a community and a society as a whole, that someone who engages in conduct such as what you engaged in should be incarcerated for the rest of their natural life and never released. And I think that's certainly appropriate in this case, given your actions. I think Mr. Trusch did an admirable job of pursuing every possible legal argument on your behalf that was warranted by the facts. I think he did an excellent job of presenting that to the jury. But I think ultimately he was faced with an insurmountable task given your actions and given the evidence in this case. Your claims that you're somehow innocent or somehow the victim in this case or somehow we're acting in self-defense is ludicrous. The amount of time that occurred during this incident between the actions of Lee entering your room and the first shot and the time between that first shot and the second shot, I think are the most compelling evidence in this case. And I think do the most to show that you acted deliberately and with full knowledge of what you were doing and full intent of what you were going to do. And I think the jury found that as well, and it's clear from their verdict. But to me, it's that timing that takes away any rational, logical argument that you felt that you were in danger at that time. I don't care what your relationship was before that day, how bad it was, or how much you felt you had been mistreated. You're an adult man. You didn't have to live in that house. You could have moved out at any time and gone on your own. You didn't have to stay in that situation. But for whatever reason, you made the choice to stay there. You made the choice to fire that first shot, which I don't even think was justified based on the evidence, given the forensic evidence of the path, the bullet, injuries to Lee, the timing between when he, like you're on the video, when he breaks in your door, when that first shot is fired. I don't think there was any reason or any justification for you firing even that first shot. Certainly the 15, 16, 17 seconds between that first and second shot is an eternity. It is more than enough time for you to have ascertained that to the extent you did feel threatened, that Lee was no longer a threat to you at that point. I think you made the deliberate, calculated, intentional decision to walk up to him and kill him. And again, I think any argument to the contrary certainly didn't convince this jury. And I don't think is ever going to convince any jury or any logically thinking person going forward. All of that, again, to me, completely justifies the jury's verdict, completely justifies the penalty which the court is required to impose. And that is life without the possibility of parole. So you are sentenced to the Michigan Department of Corrections for life without the possibility of parole. You have 281 days. Jail credit, you must pay a crime victims assessment of $130, court costs of $325, attorney fees. Is this court appointed? You weren't retained?
It is correct, it's court.
Attorney fees of $350, DNA testing fee of $60, and a $68 state cost. You have the right to appeal this sentence. Mr. Trush, have you been able to provide those appellate rights to Mr. Carson?
I did, Your Honor, if I may approach. I'm tendering to the court both the executed acknowledgement of it as well as his executed request for appointment of appellate counsel.
Thank you.
Nothing further, Your Honor.
Mr. Carson, you are permitted to investigate the state. Let's take a short recess and then we'll proceed with our morning docket. And the next case up will be People versus David's second. Let's take about a 5-minute recess.
Mr. Truce, we have Mr. Seguin.
I think he's coming back in as we speak.
Thank you. Mr. Seguin, you come right up to the front. This is People versus David Seguin, file number 256845. If I could have counsel with your appearances on.
Thank you, Honor. Richard Truce on behalf of Mr. Seguin.
This is set for a status conference today. Mr. Truce, tell me where this file is at, please.
Yes, Your Honor. In this file, we're going to be asking for an adjournment. I'm going to suggest to the court 60 days. Where we're at right now, this is our first hearing in circuit court. We have made contact with an expert here, a pharmacologist. This is a unique situation where involuntary intoxication may arise as a defense here. Frankly, this is a situation where at least one of the substances that he's alleged to have been intoxicated by was administered by a doctor and appears to be within the therapeutic range. So I'd ask for some time to explore that. We're working with the pharmacologist. At the stage we're at right now, we've made contact, consulted with him. I'm in the process of securing the funds from MIDC to retain him.
Mr. Rolla, any objection to the adjournment?
No, Judge.
Okay, I think given the nature of the charge here and the potential defense, I think that's a reasonable request. So the court will set this for 60 days. Is that enough time to?
I think that would be sufficient for us at least to be at the next stage. Obviously, I don't know where the expert's going to lead us. But.
So we'll set it for a status conference at about 60 days. Mr. Seguin, the court will send you a notice of the date and time of that hearing. Between now and then, it's important that you stay in touch with Mr. Truce so that he can continue to move forward with your case. Okay? That's right. Thank you.
And Ms. Albright. People versus Tabitha Albright. Jordan, if you can you call the jail and let them know that they want to get Mr. Yeah.
Just did run.
Oh, you did? Okay, perfect. Thank you.
Sure.
Record should reflect Ms. Albright present here in court today.
We do have an agreement that I believe we're going to take advantage of today, whereby if Ms. Albright pled to count one, the enhancements would be dismissed. So that means both the drug double and the habitual offender.
Mr. Rolla, is that a correct statement of the plea offer?
It is, Judge.
Ms. Albright, have you had an adequate opportunity to talk to Mr. Truce about this agreement?
I have, Your Honor.
Okay. And is that how you wanted to proceed today?
Yes, sir.
Here's your hand. Solemnly swear or affirm the testimony you're about to get will be the truth, the whole truth, and nothing but the truth to help you God.
I do.
Ms. Albright, you can lower your hand. Thank you. Are you currently on any kind of probation or parole?
No, sir.
And you understand that the maximum possible penalty you can face for count one, which is possession of cocaine, is up to 4 years and or a $25,000 fine.
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
I do, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. Your only appeal would be by leave, which means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
I do, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
It is, Your Honor.
Are you pleading guilty because you are actually guilty?
Yes, sir.
The information I have indicates this happened on March 3rd of 2025. Is that the correct date?
I believe so, Your Honor.
On that date, were you here in Otsego County?
Yes, sir.
And while you were here in Otsego County, did you have possession of some cocaine?
Yes, sir.
Did you know that that's what that substance was?
Yes, sir.
Did you have any legal right to have any amount of it at that time?
No, sir.
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Trush?
Defense is satisfied.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
We are not, thank you.
Mr. Trush?
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Judge.
Mr. Trush?
I am satisfied.
The court finds, Ms. Albright, that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important that you stay in touch with your attorney. And then before you leave today, you're going to meet with Ms. Davis from the probation department to set up a pre-sentence hearing.
All right. Thank you, Your Honor.
Sorry, Your Honor. And, do we have a sentencing hearing in Mr. Sesla's case today?
We do.
We do.
Okay.
Thank you.
Hey, it's trouble. So,
We can be on.
well, Polycom, okay, Polycom. Sorry.
Davis,
Yes.
on Mr. Sesla's case, do we have any kind of, I know that's a sentencing and a delay.
Did you not complete?
Didn't.
And I also wrote on there, that we need to add 14 additional jail credit days for a total of 34 days.
Okay.
You're welcome. Did you want the whole PSI?
Yeah. Whoever's disconnected, can you tell me your name, please? All right, Mr. Knudsen, can you hear me okay?
I can, Your Honor.
Okay, we'll go on the record in People versus Adam Knudsen, case number 256800, 6801, and 6822. The record should reflect the defendant's present today by video from Otsego County Jail. I can have counsel for your appearances on.
The record, I'd like to go on the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Knudsen.
Mr. Trush, I think at our last hearing you were recently appointed to these files. Can you tell me what the status is today?
Yes, Your Honor. I've had an opportunity to speak with Ms. Brooker in pretty great detail about these files. We've kind of gone back and forth quite a bit on it. We do have a resolution for the court today, which would contemplate a plea in each of the files. And I'll apologize. I almost assuredly, I don't know if I'll get the case numbers right, but we'll try.
Okay, I just need to find the information. Okay.
So in 256800 FH, it would be a plea to count one, carrying a concealed weapon. The remainder of that complaint would be dismissed, the enhancement as well as the other counts. In regards to 256801, it would be a plea to count one. The remaining counts as well as the enhancement would be dismissed. And then in regards to 256822, it would be a plea to count one, the enhancement would be dismissed.
It's an accurate statement, Judge.
Okay, so Mr. Knudsen, your attorneys indicated that the plea agreement is that you would plead guilty to one count of carrying a concealed weapon, one count of essentially felonious assault, and one count of assault with a dangerous weapon. Have you had a chance, and then all the other charges and enhancements in the three files would be dismissed? Have you had a chance to speak with your attorney about that plea agreement?
I have, Your Honor.
And did you want to proceed with that agreement today?
Yes, I believe we do, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Knudsen, are you currently on any kind of probation or parole?
I am not.
Okay. And Mr. Trush, did any of these offenses occur while he was on bond for any of the other offenses?
I don't believe so. I believe they all occurred in a relatively tight time period, and he was arrested promptly after.
And to your knowledge, were any of these, especially the assaulted charges, were any of those committed under circumstances where the court would be imposing a consecutive sentence?
I don't believe so. The most serious charge is essentially domestic violence in the home. And the other charge is not in any sort of place of confinement or anything.
Thank you. All right, so Mr. Knudsen, I'm going to go through with you to make sure you understand the maximum possible penalty in each of these charges. So in file 6800, the count of carrying a concealed weapon, that is a felony that carries with it a maximum possible penalty of up to 5 years and or a $2,500 fine and mandatory forfeiture of that weapon. Do you understand that?
Yes.
And then in file 6801, the charge of assault by strangulation, that's a felony that carries with it a maximum possible penalty of up to 10 years and or a $5,000 fine. Do you understand that?
I do.
And then finally, in file 6822, the crime of assault with a dangerous weapon, that's a felony that carries with it a maximum penalty of up to 4 years and or a $2,000 fine. Do you understand that?
I do, Your Honor.
With all those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty, Your Honor.
Right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself at a trial if you wanted. You understand all of those rights?
I do.
You understand that you're giving up and waiving all of those rights, including the right to have a trial by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to appeal it, your only appeal would be by leave, which means you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty to each of these crimes?
Yes, Your Honor.
Are you pleading guilty to these crimes because you are actually guilty of each of these crimes?
Yes, Your Honor.
Right. I'm going to go in the order.
Your Honor, if I may I assist in the taking of
That
that?
would be great.
Especially in regards to the great bodily harm. There's several events that comprise the.
Sure. And you have a much better knowledge of the facts here. So, yes, please proceed.
So, Mr. Knudsen, I'm going to start with the first file chronologically. So that is to say, were you in a dating relationship between Thanksgiving of 2024 and December 4th of 2024?
Yes.
And with whom was that relationship?
Miss Jamie Comstock.
And during that time period, was there an assault or assaults that took place?
Yes.
As a result of those, was there severe bruising to her body?
Yes.
And during that assault, was there a point or points in time in which you placed your hands on her neck?
Yes.
And your placement of the hands there, was that to restrict her ability to breathe?
Yes.
And again, that took place between Thanksgiving of 2024 and December 4th of 2024?
Yes.
And that was here in Otsego County?
Yes.
Separately now, turning your attention to December 1st of 2024, was there an altercation that took place with someone on that day?
Yes.
And was that altercation, was it a physical altercation or was it a verbal altercation?
Verbal.
And at the time of that verbal altercation, did you have a weapon?
I did.
Okay. And was that weapon, was it like a knife or a key, or what was the weapon?
It was a flare knife.
I'm sorry, I didn't hear what that was.
It was a fillet knife.
Okay.
Fillet knife.
And do you think that the person arguing with you would have felt reasonably threatened by that knife being present?
I would say so, yes.
And then now turning to this, I'm sorry, and that occurred in Otsego County as well?
Yes.
Okay, and now turning to December 6th of 2024. On that date, were you pulled over by the police?
I was.
And were you arrested on that date?
I was.
And at the time of the arrest, did you have a weapon in your vehicle?
Yes.
And was that weapon like a stick or a pole with like nails or screws through it?
Yes, it was.
And that stop happened here in Otsego County?
Yes.
And Your Honor, I think that would provide a basis for each of the three charges. Is in regards to the assault by great bodily harm, I think there's a basis either to both provisions of the statute.
Please look at the
Okay, Mr. Rolla, aside from that, with regard to the factual basis for each of the charges, would you agree that's been met by the testimony?
I would. Thank you, Judge.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
I am not.
Mr. Trush, are you?
I am not.
Mr. Rolla, are the people satisfied that the court has complied with statute, court rule, in taking this plea?
Yes, sir.
Mr. Trush.
I am satisfied.
Thank you. Mr. Knudsen, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It'll be in about 30 days. Between now and then, somebody from the probation department will meet with you to prepare a pre-sentence report. Prior to your sentencing hearing, you'll have a chance to go through that report and talk to your attorney, Mr. Trush, about that. Mr. Trush, anything else we need to address today?
I would just suggest in terms of scheduling for the court, this is likely a file that I think scheduling a little extra time for sentencing would be prudent. I know at least we anticipate bringing some information from a psychologist for the court with a diagnosis for him, as well as presenting a healthy amount of information about what he's been doing since the diagnosis has been made.
Okay. So thank you for letting me know that. The court will set aside, I think, a half an hour. Is enough time, or should we set aside longer than that?
I think a half an hour is probably good.
So we'll set aside 30 minutes for the sentencing hearing, and I appreciate that heads up. Thank you. That's all. Mr. Knudsen, the court is going to disconnect at this time.
Thank you, Your Honor.
Did you need a chance to speak to Mr. Sessler?
No, Your Honor. I spoke to him either yesterday or the day before.
Yes, sir. We're on the record in People versus Michael Sessler, file number 236612. The record should reflect that Mr. Sessler is present here in the courtroom today. This is set for a sentencing hearing. Mr. Sessler had previously been placed on a delay of sentence, although we had some issues securing Mr. Sessler's appearance for that hearing. He was then placed on that delay. He has not complied with the terms of that delay, so the court scheduled a sentencing hearing. And so, Mr. Trush, I'm in receipt of an updated report that was prepared by Ms. Davis. Did you actually do the report? Or?
Agent DeLeo.
Okay, Mr. DeLeo. Did you receive that?
I did, yeah.
Did you have a chance to go through that with Mr. Sessler?
We did. We do have some correction as to the jail credit as calculated.
Okay.
So to kind of go through it line by line, we agree with the 2 days of the initial arrest. I think that's accurate. From 4/23 to 4/30, again, I think that's accurate. The next portion for me that I showed, or I should say the Department of Corrections calculated 10 days here, but it appears that he was incarcerated from the 27th of, from October 27th, 2024 through November 11th of 2024, which I come out to 12 days credit for that as opposed to the 10 they calculated. And I have the paperwork from the jail showing the day he went in and the day he was released in regards to that, to support that release date, I guess I would say. And then lastly, I think they have his current sentence or his current credit calculated from May 20th of 2025. I believe that's accurate insofar as that's when he arrived in Otsego, but from speaking to Mr. Sesalik, he actually was arrested on the bench warrant, I think in Genesee County, and he was lodged there from 5/8 until Otsego could get him on 5/20. And I calculate that as 28. I would have that calculated 28 days, which would put us at a grand total of 50 in my calculation.
Agent DeLeo advised that he was under sentence from a peer from that case note, and then he was brought to Otsego County where he was arrested on a warrant in Otsego County on 5/21. So from 5/21/25 today, it's 14 days.
So, and again, I think, I don't know that it changes when he was incarcerated, but if he was under sentence on another county, he wouldn't be entitled to credit for that time.
Okay. All right, so that clears up the May issue. We still have the 5 days between discrepancy of November 6th and November 11th, 24.
I do have it on with PSI. That is where we came up with the 20 days. So I don't know what was provided, but I have in this one initial arrest, you got 2 days credit. 4/23 is about 8 days. 11/1 to 11/6, you got 5 days. Here's a big credit. Okay. So what was changed here was 11/1/24 to 11/6. And then show that we brought that to the county jail. So 5 days. This is what was changed at the sentence. And then 10/27/24 to 11/1/24, another 5 days. Held for Otsego pickup. So you get a total of 20 days jail credit. The PSI was changed at the sentence.
So 34 is.
So 34 would be the total jail credit.
Right, that would be consistent with the court's order of May 21st, 2025 for respondents.
Okay. So I think that number is clarified, 34, what he's entitled to at this time.
All right, thank you. Any other corrections, Mr. Drew?
Corrections? No.
Roll that in corrections.
No, Your Honor.
Anything on behalf of the people for allocation?
Judge, restitution is not paid in full. We have no objection to the recommendation.
Mr. Church.
So, Your Honor, a couple things I do want to point out to the court. Obviously, this is a situation where a substantial amount of restitution was paid up front. I emphasize that to the court because I do think it's relevant in terms of what the court does. He did work very hard to come up with a substantial sum of money to pay that restitution. The other piece that I would indicate to the court, and I think it's kind of clear from the record, but I want to make sure we detail some dates for the court. And Mr. Sesalik has struggled to get his feet under him as this has happened. The court is probably aware there's been several incarcerations in other counties as this has gone on. Some of them have been referenced today, but he was incarcerated in Genesee County for 3 months in the time period of June of 2024 to September of 2024. Lapeer County was incarcerated from November of 2024 through February of 2024. And then again, we just heard from probation and parole at the time that he was brought here, he was serving a sentence in Genesee County, again, incarcerated there before he was transported here to take care of this. I think it's an unfortunate situation, and I think it's fair to say that the supervision here really never really panned out and materialized, didn't go well. But I also think that part of that is because, Mr. Sesalik can't get his feet under him because of the incarcerations. What he is indicating to me is that most of those incarcerations were on child support issues. But still, I mean, he's unable to get out. secure work, get on his feet, and as soon as he's able to do that, he's reincarcerated. I would suggest to the court, I don't think a lengthy jail sentence here is appropriate. I think discharge obviously is appropriate. I don't think continuing on the same path of supervision is appropriate, given that it hasn't worked to this point. But I do think, given sort of some of those circumstances surrounding it, and given that restitution has been made in full, I would suggest to the court discharging him from the supervision, having that conviction abstract to his record, and leaving it at that would likely be appropriate.
Thank you, Mr. Seslick. Anything you want to say?
This is Mr. Sutter. It has been difficult, the getting in and out of jail with the child support, and that's what it has been. Most of it has been. And like I said, it is difficult coming out and trying to get caught up with that child support. Like I said, every month I'm in jail. It costs me an extra $1,700 a month. It keeps racking up to $1,700 a month, so I go farther and farther in debt in the child support. I do got another court date on June 10th for child support, so just trying to get through this, get back on my feet, so I can get back to my railroad job where my goal is to get. So I'm trying to get out and take care of my child support and get back on my feet, so I can get steadily back to where I need to be.
All right, I had a chance to review the original PSI as well as the update prior to the hearing today, and looking at the way things have gone, which has not obviously been the way that I think all sides were hoping and anticipating to go at the time of the original sentencing hearing. And I do think that although this is a 1-year misdemeanor, the court could sentence you to up to a year in jail. I think the fact that you paid back the restitution at a time is a mitigating factor. Of course, your circumstances while you were on delay is a negative factor. I think balancing those two things, a 90-day sentence is appropriate to address your wrongful conduct, but also give you credit for paying the restitution up front, trying to make amends for this case. So I think that's a reasonable sentence that accounts for both of those factors. The court will sentence you to 90 days in the Otsego County Jail. You have credit for 34 days served, or will discharge you from the delay. Will no longer be under intense supervision once your sentence is served. You have the ability to seek an appeal of the sentence, and Mr. Trush,
Your Honor, because the delay is on a 1-year misdemeanor, I think he only has oral appellate rights.
Oh, that's right. Okay. So, Mr. Seslick, if you did want to seek an appeal of this sentence, you can file that paperwork within the next 21 days. If you have further questions about that, Mr. Trush will be able to answer those questions for you. Mr. Rolla, anything further that we need to address for the record today?
Mr. Trush.
Please, sir.
Does the court include in its order the majority of previously the court cost? Not that information. I don't know if it was imposed in the court's original order or not. That's the only reason I bring it up.
It was, so the court will preserve any outstanding findings.
Very good. That's all I'm requesting. Thank you.
Great, that concludes the morning docket. We'll be in recess until 1.